Hi, this is Eric Hess with the Encrypted Economy. This week we have Drew Hinkes, partner at K&L Gates, on the podcast to talk about the limits of code deference. He is quite prolific in the digital asset space. He's one of those lawyers, he's a professor, he manages a law practice, he's active on social media, and he writes very thoughtful law journal articles, like his latest, The Limits of Code Deference, which I've dropped a link for into the show notes. I'll give him extra credit because 20 minutes before we were supposed to take this podcast, my computer crashed and he waited graciously and he only charged me half his going rate. So I really appreciate that. With that said, Drew manages to make this concept very understandable for anybody who's a non-lawyer. So don't be intimidated by it. And he's a professor, so he knows how to explain things. He doesn't only just act as a professor for law, he also acts for MBA. So he knows how to speak, I guess, to business, to lawyers, to developers. So he has wide-ranging appeal. And before I bring you Drew, please, this note, share this podcast if you enjoy it. My numbers have seen a nice bump. I want to see 4-digit downloads. I'm not there yet. So I need your help to make that happen. So with that, I hope you enjoy this podcast and so you can share and get me closer to that goal. With that, I bring you Drew Hinkes. Welcome to the Encrypted Economy, a weekly podcast featuring discussions exploring the business, laws, regulation, security, and technologies relating to digital assets and data. I am Eric Hess, founder of Hess Legal Counsel. I've spent decades representing regulated exchanges, broker-dealers, investment advisors, and all matter of fintech companies for all things touching electronic trading with a focus on new and developing technologies. So this is Eric Hess with the Encrypted Economy, and I have Andrew Hinkes, partner at the law firm of K&L Gates. He's also an adjunct professor for both NYU Stern and NYU Law. K&L, Drew's transactional regulatory and litigation practice focuses on digital assets, blockchain, smart contracts, and how these new technologies interact with existing law and regulation and impact legal relationships. Welcome to the show before I get into that. So thanks so much for coming on.
Oh, thanks for having me, Eric.
I gave a little bit on your background, but do you want to kind of give a little bit more about what brought you to digital assets and your journey?
Sure. Thanks so much. Again, it's great to be here. I got involved and interested in Bitcoin in 2013 when actually a friend's younger brother started trading it. And I was a lawyer. I was working primarily in litigation at the time, and I knew very little about cryptocurrencies and blockchains. But my initial impression was you got to be careful. These things are sort of ill-defined under the law, and you want to make sure that you're not doing something that's illegal. My friend's response was, no, you're missing it. This is potentially transformative technology and really something that's up your alley. I have a technology background prior to going to law school. And so for me, these technologies and these systems and all the really interesting questions that they create just fit me like a hand in a perfectly shaped glove. From about 2014 on, I decided that this is what I wanted to focus my legal career on. And I guess things are going well since I'm here talking to you today.
Excellent. And I warned you about this ahead of time, a personal event in your life that shaped your values and worldview.
Sure. So I grew up in Miami, which is a very diverse place. There's extreme wealth and extreme poverty. There are people from all over the world. And growing up in Miami gave me a perspective and an understanding of the world. And then I went to college in the Midwest in a community that was very different. And so it showed me that things are different as you go to different places. People have different experiences, and not to sort of preconceive or judge because you never know exactly what anyone is dealing with and what challenges they're looking at the time. It gave me a lot of insight as to the different circumstances in which people can be raised and come from. And ironically, some of those experiences are what drew me into cryptocurrency and blockchain technologies, because there are obviously some pretty material opportunities to use this technology as a democratizing force and as sort of a leveler of various financial and economic playing fields.
Excellent. So Drew and I did not have a talk before the podcast, but I mean, we figured, what could go wrong? To move on to the topic of the podcast, what do you think about whether chimpanzee sanctuaries should be vaccinating the primates against COVID-19 or not?
My opinion is that you should be asking a doctor or a primatologist that question. I'm just a lawyer that tries to help people deal with some sort of very narrow band of technologies.
That's a good answer. Good answer. No, actually, that was levity. So Drew wrote an article on the limits of code deference, which he published in the Journal of Corporation Law, which talked about how do you enforce law in smart contracts at a very high level. And I read this article, very well written. I encourage everybody to do so as well, because it's a very important topic as we start to think in terms of the overall encrypted economy and decentralized, the decentralization of projects and smart contracts. Drew, why did you choose this particular topic to write this article about?
So for me, the idea of these assets and technologies becoming legally significant really solidified when I tried to understand the DAO from 2016. And in my view, the DAO was really the structure, the project, the event that really showed in stark relief how there were going to be challenges brought by the law intersecting with code. And if you recall, the DAO was a project that did not use an incorporated form and allowed token holders to vote on the use of property. And it was a bold and audacious project pretty early on in the history of crypto and very early on in the history of Ethereum that became very popular and crashed spectacularly when someone exploited what appears to be a defect in the code. And since then, the DAO and the resolution of the DAO brought forth a tremendous amount of ethical issues, legal issues, economic issues, and it basically previewed everything that we're still struggling with in the legal world as affects these assets and these systems and these structures. And so, notwithstanding the spectacular success and failure of the DAO, we still see folks experimenting and using decentralized technology in ways that are increasingly important. And an underexplored area of this is what happens if people have disputes. Forget about an attack or a hack where somebody steals a whole bunch of value from third parties. What happens if there are parties that are trying in a good faith way to conduct their affairs using code-driven projects and code-driven structures, and there's a bona fide dispute? It occurred to me that litigation could be really, really damaging. It could paralyze a project, or it could altogether just destroy a project because of the way that law imposes its will over systems. And so looking at the DAO, thinking about the conflicts that were created there, as well as some discussions that I had with a friend of ours named Gabriel Shapiro, who probably his name, if not he himself, has probably popped up on this podcast or some other podcasts involving decentralized technology. After a few of those discussions, I came to determine that it made a lot of sense to think about, if you are going to use technology to coordinate the actions of a number of parties and to allow those parties to control property, there needed to be ways to handle disputes. A project like the DAO didn't really conceive of this. It wasn't on their radar at the time, or they never got there, so to speak. But modern implementations of decentralized technology and DAOs have started to think about how to deal with the problem of the law. And so I thought it made sense to look at what we learned from the DAO's success and failure, as well as a few attempts to insulate and build around DAOs with legal wrappers, to figure out how people are approaching this problem of code is code until the law steps in. And then the law is going to essentially trump whatever the code provides. How can we address this problem? Where are there tension points? Can you design around this? Can you contract around this? And if not, what does that mean? That was the basic idea of the paper.
Well, great. And so to take a step back from all that, to start off with the smart contract, let's talk about a little bit what a smart contract is. I'll let you take that one.
Sure. So a smart contract is a direction given to a computer system, right? It's a piece of code that tells software how to execute. There's been some very creative and intriguing messaging around smart contracts as a technology that's going to change commercial relationships, perhaps even eliminate the need for transactional lawyers. And while that's interesting to think about, and maybe one day the technology will evolve to that point, for now, you can think about smart contracts as code that can automate certain transactions. Those transactions and the execution of the code can be part of a series of representations and agreements that could amount to a legally enforceable agreement, a legal contract. But smart contracts themselves are not necessarily legal contracts. They're best understood and thought of as instructions to computers.
Great. And so when disputes occur that are related to smart contracts, whether or not they could be contemplated as a contract in and of themselves with other things or as part of a contract, what types of disputes do they typically create, and how are they different from traditional disputes?
So they aren't that different from traditional disputes in the sense that you're going to have a dispute over the execution of code because some sort of expectation is not met. You expected the code to do something and it didn't, and it caused you harm. You might want to bring a claim against somebody else, whether it's you're going to ask them to do something to fix the problem, or whether you're going to run off to court, file a piece of paper, usually called a complaint or a petition for some relief, and ask the court to determine whether you're entitled to that relief. What you see with smart contracts, though, is that there's some additional complexity because smart contracts are generally designed to operate in certain ways. Once the terms of the contract are put into motion, they're difficult to change, and that limits what courts can do. They can't tell the code to rewrite itself in the middle of a transaction. So if the code takes control over a digital asset and will only give up control over a digital asset under a certain set of circumstances, if a court orders that the asset be turned over, there isn't really a legal person that can effectuate that order. Court order can't rewrite code. And so as a result, you've got structural differences in the way that assets controlled by smart contracts can be handled versus assets controlled by legally addressable entities. If there's a bank, for instance, that holds some asset, a court can send an order to the bank and say, you need to turn over this asset to this receiver or trustee, for instance. And banks are legally addressable. They understand that they're subject to court orders, and they will generally either respond in some meaningful way to the legal order or comply. It could be that based on the structure of smart contracts, certain types of orders cannot be complied with. And I know that there's always going to be someone that says, well, there's always a human behind a smart contract, but ultimately that human may or may not be able to change the thing that they have deployed. The result is that certain remedies that are available by courts may or may not be available to be implemented against assets that are controlled by smart contracts. You might only be able to have ex post or ex ante remedies as opposed to remedies that affect assets while they're in the process of being transacted by a smart contract.
And so in the context of a dispute or raising a dispute, how does it differ when the dispute is the result of the code, let's say a coding error or some unintended consequence within the code, versus the representations that occur outside of the code, perhaps marketing and other collateral materials?
Sure. So again, you're generally going to have a legally addressable actor, a legal entity that's bringing the complaint. It's going to be a person or it's going to be an entity, and they're going to say that they expected or they had agreed that certain things were going to occur and that they did not occur. If there's a representation in marketing materials that said, when you take a right, you're going to, or when a certain thing occurs, you should expect an outcome, and that outcome does not occur, then you might have a relatively easy claim to bring. It would be relatively simple to explain to a judge. I was told this was going to occur. I changed my position to my detriment, expecting that that would occur, and it didn't happen. When you get into claims that are based on the way that smart contract code operates, now you've got a whole different set of considerations. First, who wrote the code or is responsible for it? How do you explain that those expectations were not met? Because if it's something along the lines of there was a series of 9 smart contracts that were supposed to execute in a certain way in order for this transaction to occur, and I think that there was a problem in the way that the 5th one acted, which resulted in the subsequent 4 not acting properly, which then deprived me of some asset. It really is a question of what level of detail is necessary to state your claim in front of the court. It could be that you simply say, I expected these code segments to work in a certain way and they didn't, and as a result, I was deprived of some property, or I did not have my expectations met. I think it's going to be up to the lawyer or the party making the claim to determine how, in what level of detail they want to make that allegation. Certainly, it's simpler to say, I was told that you were going to, drop a gallon of milk off at my house and you didn't do it, versus there was this intricate machine that was supposed to result in a gallon of milk being dropped off at my house, and this one particular segment of the code that was supposed to do.
So, and how does that change with code transparency? If the code is transparent to the person who's relying on it, is that enough?
Well, so when we talk about certain types of claims, including torts, meaning non-contract claims alleging damage, we talk about reasonable people. There's this idea that there's an average person out there that behaves in an objectively reasonable way. And a lot of tort law revolves around whether someone was acting reasonably or not. One of the things that is going to be considered is whether a reasonable user of this system should be required to read the code and understand it prior to using it. It would seem to me at the moment that there is a very small population out there that can program and reasonably understand Solidity code, for instance. Let's say we're talking about Ethereum. And so it seems unreasonable or unlikely that a court would say, in the case of a dispute, well, you as the user of some smart contract platform really should have audited the code yourself to understand what you were doing before you decided that you're going to commit some commercial assets to the code. That seems to me unlikely. On the other hand, if you've got a project that says, here's Drew's magic machine, you put $1 in and these 3 things are supposed to happen, so put your $1 in. It might be enough that a reasonable person would rely upon the representations. This question, really what you're getting at here is, where is the agreement in a smart contract or in a venture that's built out of smart contracts? There's a great paper by Coney and Hoffman that talks about smart contracts as being part of a legal contracting stack. And that when you think about a smart contract, generally there's going to be a set of representations and communications, at least for smart contracts that are used by 2 parties to transact. And that all of those representations and all those understandings together with the code and how the code operate will create a contract, and that it's usually unlikely that any party is going to rely upon and need to audit the code to understand what's going to happen, because it would generally be, I'm going to deliver the milk at noon and you're going to pay me $1, great, no problem. Oh, and we're going to use this code to handle a certain part of what we agreed to. Okay, great. The code itself is not going to be the thing that is analyzed. It's going to be the overall agreement or representations that were made as part of the agreement.
And what about jurisdiction? Are there unique jurisdictional issues that you encounter in a claim for smart contract pursuant to a smart contract?
There's a button. Sure. So there's a bunch of different types of jurisdiction that you have to think about. There's subject matter jurisdiction, which means it's the type of claim that the court can deal with. And then there's jurisdiction over the dispute as far as, is the court in the right place to handle the dispute, and jurisdiction over the parties, meaning are the parties located in a place where this is the court that can actually exercise power over them. Subject matter, like we talked about, you're going to have torts and you're going to have contract claims involving smart contracts. Either I was damaged because this thing didn't work properly, which would seem sort of like a tort claim, or I had an agreement, we were going to use this technology to accomplish the agreement, and one party didn't do what they were told or what they were expected to do, which would be a breach of contract. As far as jurisdiction over the dispute, generally speaking, a claim accrues in a place where someone is damaged or where a transaction that was supposed to occur did not occur or occurred in a way that was defective. If we're talking about internet, blockchains, online transactions, it's hard to determine which court has jurisdiction over the internet. There have actually been 2 cases that have looked at the question of where does a transaction on a blockchain occur. One of them was one of the Tezos matters of a federal court in California. The other one was a case involving, I think it was a trademark dispute actually, involving something called Alibaba coin that I believe was out of the Southern District of New York. The Southern District of New York case more or less looked at and applied the precedent that applied to internet commerce generally and said, we view a transaction to occur where the party accepted the transaction, which is where the human being was sitting when they pressed the button on their computer. And we don't really care if the blockchain has nodes in this country or has nodes in that country, because we have made this rule for internet commerce where we've sort of, we haven't really cared where the server is located. We've really cared about where the transaction is created and occurs. The Tezos court looked at things a little bit differently. They looked at a bunch of different factors, including where the blockchain nodes were, including where the server hosting the website that was acting as the front end was, and determined that they were going to think about all of those factors. So from a jurisdictional perspective, it probably makes sense to think about existing internet jurisdiction with the understanding that some courts may look at additional factors. But if you are looking at where a smart contract transaction occurs, a good place to think about is where are the parties. But this is a lot more complicated if you're dealing with decentralized ventures like Daos, because who is a DAO, right? That's an interesting question. Is a DAO a legally addressable entity? Is it a legal DAO where there's an entity that's formed and the governance of that entity is conducted by people who are using smart contracts or are using digital assets as a way of participating in governance? Or is the DAO not an expressly addressed legal entity where there's a bunch of people that are using technology to signal what they want to have happen, some asset that's also controlled by that technology? In the case of a DAO that isn't incorporated, a court might look at the facts and might decide that they're going to use gap fillers or default rules in order to look at the facts and assign them legal significance. They could say, well, that looks like a general partnership or a joint venture, which might have some very bad consequences for the people involved. There are also some states that have created default rules for groups that don't act under legally addressable entities. A lot of things that we think about as traditional organizations actually were not generally legally addressable entities. Churches, religious organizations sometimes don't incorporate. Labor unions sometimes do not actually incorporate. They're just loose affiliations of parties acting together. So some states, like Georgia in particular, actually have civil procedure rules that talk about unincorporated entities still being able to sue and be sued, and procedures to designate a representative. So there's a lot to take apart in what looks like about a 7-minute rambling monologue there. So I'm going to be quiet here, Eric, and let you get this back on the rails for me.
No. It's an important point when you consider basically bringing claims against smart contracts is where it is and who the parties are. And you even touched on a point with regards to DAOs. There's a lot of discussion recently about whether a DAO should be a legal entity or traditionally in a lot of cases DAOs aren't. They're just formed. But a lot of times the participants don't understand that potentially impacts their liability since there's no entity to sue. Now it's in the individuals. And it's that topic I actually want to return to after kind of exploring some of the process components for bringing claims. So in bringing a suit against a decentralized venture, you may not know where that venture is. You also talked about some of the complexities, both in, if you do bring a claim, how do you, once the claim is brought, the various things that have to occur after that claim, whether it's a discovery hold or even things after the judgment, injunctive relief, both of those scenarios involve an actor, inserting themselves into the process and undertaking those actions, where in a decentralized venture, they may not exist. Do you want to expand on that, the complexities of that a bit, and how sometimes courts or even DAOs, manage those kinds of situations?
Sure. So if you want to sue somebody, at least in the United States, you usually file something called a complaint. And the complaint lays out the legal theory and the facts that, according to the plaintiff, that is the party that's asking for relief, believes are necessary to explain on a broad level why they're entitled to a judgment and to ostensibly recovery. The first thing in a complaint is the name of the parties. First you have the name of the court, then you have the name of the parties. So it's Eric versus somebody. Who are you suing? If you're suing a DAO or a venture that uses smart contracts, the first thing you got to think about is, who am I suing? If there's a DAO that is not legally incorporated, you may or may not be able to figure out exactly who you transacted with. If you used a piece of software that is functionally an appliance online where there isn't a legal entity that stands behind it, you may not know with whom you actually transacted. You may not transact with anybody at all. And that can get very complicated, because if you can't name a defendant, then you can't serve them with process, which means give them something called a summons that tells them when they need to respond to the complaint, and a copy of the complaint and attachments. If you don't give somebody a summons and a copy of the complaint under US law, you cannot proceed in your case against them. So you got to figure out, who am I serving? And so if you're serving, or if you want to sue at a unincorporated entity, you have to figure out who is the person or the entity that stands for that party. And that's a question of who is an agent or who represents that party. In the case of an unincorporated DAO, where they maybe aren't using a legal entity, there are a bunch of different theories, none of which have actually been tested to my knowledge in a court case that's been appealed where there's been law created. But it's basically assumed that if a bunch of people acting together without a legal entity to control some property would be considered either a joint venture or a general partnership. Now, this conclusion has a bunch of really important implications. The first of which is, everybody is the entity. Everybody is the collective. That means if you want to sue DAO ABC that is not incorporated, all I need to do is find any participant in that DAO entity and serve them. And I can claim that they stand for, they're participants in, they're agents of, and they would then be representative of the DAO. And then the burden shifts to that person to try to assert otherwise. I only own the tokens. I've never voted. I don't control anything. I just bought and sold these things. There's some real questions as to who is and is not actually representative. Imagine a DAO that requires token holders to sue. Would anybody who holds any token be an agent that could be sued? Hypothetically, you could serve a crypto exchange and say, because you own tokens or you are holding tokens for third parties, you are acting on behalf of this decentralized group of people. It would be a weird outcome. I'm not sure if it would work, but literally you could hypothetically make the argument that anybody who holds the tokens, even if they're not participating actively in governance, might be someone who could be served. Now, most of these projects don't require participants to give name, address, phone number, social security number to participate. And they generally don't geo-block participants. So you might have a difficult time finding someone to serve. And if you can even figure out who they are, locating them and serving them, because service is an in-person thing. You generally have to physically provide somebody with a piece of paper and get proof that you have served them. However, you only probably just need one. And if you can get that one, then that party or that person is on the hook to respond. And that means even if they have great arguments, they probably have to spend some money to get out of that position. And it's not entirely clear as to if that person says, I literally just bought these tokens, I don't know anything about anything, I certainly didn't have any involvement in any of these decisions. It's not clear exactly how a court would look at that argument.
Right. And certainly the court wants to know ultimately that somebody, if there's an aggrieved party, somebody arguably needs to be liable, at least in the eyes of law. So if you have a case where that liability has been accepted and it's a corporate entity, there's a path for that. But in the absence of that, is it sort of a case of duck, duck, goose, and whoever manages to who doesn't get picked, they escape, but that increases the risk for the person who remains. Meaning, if you're a member of a DAO and everybody's done a phenomenal job of insulating themselves against potential liability, then it really seems to put the burden on the person who is least protected, in that group. Because everybody else has.
So it's the bear theory. I don't have to be able to outrun a bear. I have to be able to outrun the slowest person in my group of friends in order to be safe from the bear.
That beats my duck, duck, goose example for sure. So yeah, 100%.
Exactly. Yeah, and that's one of the potential vulnerabilities involved in using a DAO that does not have legal significance or that's not a legal entity. It could become every participant for themselves. And then those participants could end up roping in the other known participants. So because if you're a JV or a general partnership, you might have full joint and several liability for the entire venture. So that means if there's a DAO that controls $200 million worth of assets and someone gets a judgment against you, poor, unlucky, unfortunate you, they might get a judgment against you for that whole $200 million.
Right.
It would be you in your context as a representative of this entity, but maybe you're a small time player. Maybe you don't really have much in the way of assets, and you certainly don't have any ability to get to that assets. And I think that those arguments would be brought up.
Does that type of issue exist in a DAO entity on some level? Meaning, even under the law, a DAO entity, if it's incorporated, it is protected from liability to some extent, but a judgment against a DAO, if there are members that are known and the DAO is less known from a regulatory context, certainly a regulator could go after the participants under promoter liability or what have you. But does that also have an implication under just, a normal lawsuit, under the court system, I should say?
Sure. So one of the most important reasons to incorporate is that you are given a shield from liability for the actions that are undertaken under the auspices or under the guise of the entity. So if you and I decided that we wanted to, manufacture ceiling fans, and we went out and we entered into a bunch of contracts and we bought a bunch of raw materials and we built a factory and we made ceiling fans, and then, great. It's the Drew and Eric ceiling fan brand. Fine. One day the ceiling fan falls and hits somebody and hurts them. And we default on paying the lease on the factory, and our metal supplier, we stiff the metal supplier for several months. If we don't have an incorporated entity, those folks can say, well, I had a deal directly with Drew and with Eric, so I can go and I can recover directly against Drew and Eric. However, if we make, E&D Fanco, and it's an incorporated entity, and it complies with all corporate formalities, and it's the party that enters into all these contracts, then in the absence of us abusing the corporate form or additional facts of us committing some sort of fraud, generally all those obligations belong to the company, not to us. And so corporate form is an incredibly powerful thing as far as the ability to organize and to shift risk. It's a thing that used to be, at least under the English common law tradition, an exception from the rule that only legal breathing humans were legal actors. It used to be that you had to actually get a charter from the crown in order to act under a fiction. Now, because it's so helpful for organizing capital and for building out the economy, so rather incorporating an entity is a pretty much a easy pro forma process. For all the corporate lawyers out there who are shaking their heads at me, the entity is easy. All the corporate documents and understanding the allocation of liabilities and rights is complicated, and that's why corporate lawyers, get paid well to draft things like bylaws and operating agreements for entities. But these are really, really critical risk-shifting organizational techniques. And they are the reason that people use them is so that they can engage in commerce without taking on personal risk. So going directly to your question, if there's an LLC that enters into some transaction or a corporation that enters into a transaction, there's a claim against it. Generally speaking, in the absence of facts involving abuse of the form or fraud, the individuals acting through that entity are generally protected from liability.
Right. But in the context of a DAO, let's say that the entity itself is, obviously there's no one managing the DAO. There's no person to serve against the DAO. Does this also raise some of the bear chasing issues where the DAO has outrun some of its identified members?
Is the DAO you're talking about a legally incorporated entity with decentralized governance,
Yes.
Or is it a group of people acting?
Assume that it is a legally organized entity with decentralized governance.
Sure. So a legally organized entity in every state that I'm aware of in the United States has to have a registered agent for service of process, whether it's an outside company or a designee. The location and the officers, directors, or members are generally going to be public or available from the relevant state Secretary of State. So it's not difficult to figure out who you serve and who the representatives are. Whether those individuals are liable for the bad acts that led to the presumed harm is a separate question, mostly because if it's an entity you're contracting with, it's the entity that is liable, unless there's an individual who is abusing the corporate form or committing fraud in some manner. Generally, that's the law about when you can do what's called piercing the veil, which is avoiding the corporate form and going directly against a bad actor personally. Generally speaking, there needs to be something beyond the regular operation of the business in order to pierce the veil. Simply running out of money is not considered one of those things, but actively deceiving people, committing some other bad acts under most jurisdictions' law that I'm aware of would allow you to pierce the corporate veil. It's not simply being a bad business person.
Okay. So in terms of forming a DAO entity, in terms of trying to limit liability, because in some cases, if the DAO, I think in your article, you note that, it may not be possible for a DAO to completely insulate itself. It can't have terms that are so arduous that a court could look at it and say, we're not going to enforce this because it's ludicrous, right? You can't completely insulate yourself against every single form of liability. We don't accept it. And maybe we should talk about that first. But, how do the courts view, like in the, where the DAO itself is, the DAO itself is outrunning the bear and outrunning its participants. If the DAO has been constructed in such a way that it's so remote from any potential action, is that going to be enforced by the courts?
So in the United States, our law is very flexible, and it generally allows parties that are dealing in good faith, provided that there's no overreaching, duress, or anything else, to arrive at agreements, and for those agreements generally to be enforceable. Now, just because we're allowed to agree to do something doesn't mean that we can agree to do anything, right? If I agree to go and commit a crime, that's generally not going to be considered an enforceable agreement. Where if I say, you know what, Eric, I am not going to do that, where you could then sue me and say, well, you agreed to go commit this crime and we have an enforceable contract. And there's other things that we can't necessarily do by agreement. A parent and a child cannot agree to vary the driving age. by private agreement. A building owner and a demolition company can't decide that they're going to demolish a house at a time that's at their convenience in sort of derogation of a zoning law. And as we've learned from some of our ICOs in the 2017-2018 vintage, private parties can't put in a contract, we agree that this thing we're selling isn't a security, and have that be binding on regulators. There's a very strong line of cases in the United States that says you cannot waive obligations that inure to the public benefit. You cannot waive obligations or laws that are intended to protect third parties. So you could do a lot by private agreement, but you can't waive securities laws. You can't waive the ability of a party to sue altogether, because a waiver of the ability to sue in a litigation becomes a defense or a counterclaim against the claim itself. You would sue saying, the Dow hurt my feelings, and the response would be, you should dismiss this because there is already a waiver of the ability to go and seek redress from the courts in this contract where you said that you would not sue over hurt feelings in these transactions. And then it would be up to the court to decide whether that was in fact a complete defense to the lawsuit or not. And what's critical here is it is not something that keeps me, as the guy with the hurt feelings, from filing the lawsuit, from serving you, or from you having an obligation to respond. It might be an absolute defense to any liability of my claim, but you still have to go through the motions. You still have to deal with the paperwork. You still have to spend the money, and you still have to actually assert the defense. This goes for waivers. This goes for covenants not to sue. This goes to releases. And so there is no way through an agreement to functionally deprive someone of their ability to walk up to that clerk's window and file your complaint, unless a court has already entered what's called a pre-filing injunction. And that is where the court says to the clerk, do not accept more paperwork from Hinkes. Hinkes is not allowed to file lawsuits here anymore. This is, again, not something that you can do by a private agreement. This is something that's an extraordinary remedy generally used against serial filers that are abusing the system or harassing somebody by using the legal system. They're rare. They don't happen very often, and they're not something that you can do through a private agreement between two parties. So the best agreement in the world that says you waive your ability to sue me, you're enjoined preemptively from suing me, you've released any claims that you would have in the future, cannot stop somebody from filing the complaint. It simply creates defenses or perhaps counterclaims.
So trying to basically have the members or people entering into these contracts waive their right to sue doesn't work. It certainly, it itself may be subject to attack. So I think you talked about other ways to sort of manage that, where it limits the ability of a claimant to bring a dispute without depriving them of that fundamental ability. Do you want to kind of expand on the best practices that can be pursued in that regard?
So I don't know that the industry has matured to a point where there are best practices in the sense that you would expect, where best practices are sort of tried and true ways of dealing with problems. There have been a few brave and bright people who have offered up a couple strategies. The paper that you referenced earlier looked at the Metacartel Laos Pact and looked at the Laos operating agreement as two ways that folks that are trying to build decentralized ventures through legal entities have tried to address this problem. And this problem of getting people to defer to the operation of the code rather than sue each other in court is what gave rise to the name of the paper, which is The Limits of Code Deference. So we use the term code deference to describe the attempt to get parties who are engaging in these ventures to resolve their disputes and defer to the code, and not to resolve disputes perhaps in the conventional legal system. So we've seen a few different strategies. We've seen folks that attempt to use waivers and use covenants not to sue preemptively when entering into one of these ventures. And we have seen, and that's a strategy that, as I explained before, creates impediments, increases the opportunity costs of trying to sue, and creates good defenses for the venture itself. And so what it does essentially is it makes it more difficult to actually get relief by suing. We've also seen ventures that attempt to create onboard dispute resolution, so that instead of going and suing somebody, you can propose a new project or an action that would essentially reverse the action that you claim harmed you in some way. You can also, in certain cases, ask that the thing that harmed you be reversed, as opposed to it being in the context of a new project or new proposal. Some of these ventures will allow you simply to, take your ball and go home. You can do what sometimes is called rage quit or exit the venture. And then there are other ventures that sort of take the contrapositive approach, not the opposite, but sort of the other way of thinking about it, which is everything that happens through the distributed governance is effectively thought of as a approved action of the entity in writing, which means that it is prima facie going to be viewed as valid. And so if somebody wants to try to avoid that, they essentially have to sue as though the corporate secretary took the notes down wrong. They have to sue essentially for relief from what they would say was a misprint. And the argument there would be, even though everybody voted that we should change our logo to blue instead of green, the way that we voted resulted in the vote being recorded wrong, and it improperly or wrongly showed the outcome being green. Since we all voted for blue, but it was merely the recording of the outcome of our vote as green, the court should order that that record be amended or reflect the actual vote. And so, again, this is a fact-sensitive type of suit that would have to be brought. You would, again, be able to find a legally addressable entity to serve. And it could be that a court would have to get into some very nitty-gritty issues of, how do we know what everybody voted on? Where are the records of the vote? How do we know that is the system that malfunctioned, and how can you prove that? And so, again, none of these provisions, none of these strategies can stop somebody from suing, but they can make lawsuits difficult. They can make lawsuits expensive, and they can create defenses or, in certain cases, counterclaims against the party that is suing, all of which makes it less attractive to go and sue. And there might be folks who just want to sue because they just want to sue, and none of this will matter to them. But for most people that are actually interested in getting relief for some perceived wrong, all of these strategies can sort of direct those people back to onboard resolution as a better alternative.
What are your thoughts about on-chain dispute resolution, meaning like a third party on-chain, third parties like a Claros, for example?
Sure. So I want to stay away from specific implementations or companies, but on-chain resolution could be viewed as kicking the can down the road, so to speak, because it's unclear as to whether on-chain resolution comports with due process, where even if there is an on-chain dispute resolution outcome, a party could sue over that, saying, I didn't get a chance to present evidence, I didn't get a chance to give testimony, this did not accord with fundamental constitutional fairness, and therefore, court, ignore that nonsense. It's not binding on me, and I want you to adjudicate my dispute according to the law. And there have been cases where parties have used alternative dispute resolution provisions, and then the court has found that those ADR provisions are illusory because the means of dispute resolution doesn't really exist, or because it does not allow anybody to actually get relief, or because the relief does not accord with due process. You're not allowed to give evidence. You're not allowed to advocate on your own behalf. There's a rubber stamp process that says you lose 100% of the time. And so I'm not saying that any of the on-chain ADRs will suffer the fate of some of these really obviously illusory ADR systems and strategies. But my suggestion is that unless it is something that accords with constitutional due process, it is possible to attack. However, these systems, like the contractual dispute resolution that we mentioned before, do continue to shift the incentives, do continue to shift the burdens, and do continue to increase costs. Because you have to go through this ADR, then want to attack later, and then perhaps the entity can have an additional argument, which is you agreed to ADR, you went through ADR, you got a resolution that you didn't like, and now you're trying to again breach your agreement that you made with us that said that you were going to agree to be bound to this ADR. And so by putting up additional roadblocks, by creating additional expense and complexity, it makes suing to get compensation or a relief less attractive, and makes operating within the confines of what is available on the system more attractive.
Well, great. So this was, before we break, any other points you want to raise on the limits of code deference?
There's a lot in the paper. If anything that I'm talking about is interesting to you or to your product or to something that you're developing, I would encourage you to pull the paper and take a look. It is written for lawyers, but I think that developers would definitely find some of the arguments and some of the examples helpful. And the good news is it's academic literature, so it's out there for free. I encourage everybody to read it.
Yeah, no, it is an excellent paper. Another reason why I wanted Drew on to talk about it today. So thanks so much for joining us. It was great to have you on, Drew.
All right, Eric. Thanks for having me, and thank you.
And before we break, where can people find out more about you, whether on social media or what have you?
Sure. So I'm on Twitter, and I'm pretty active on there. My handle is @propelforward. I also have a website. It's my name, www.andrewhinkes.com. And of course, I work for the law firm of K&L Gates, and so you can find information about me on their website as well. And obviously, I love to interact with folks who are active in the community. I'm always trying to learn about new projects and new developments. So please feel free to be in touch.
Excellent. Thanks so much.
Thank you.